Kenneth Anderson entered the courtroom asking for a second chance, and the judge gave him one. But the warning attached to that second chance was crystal clear. His daughter could never become an excuse for breaking the law again. Then, according to the court record, Anderson allegedly violated community control with another domestic violence offense while still under supervision. What follows is a dramatic shift from probation and rehabilitation to a prison sentence. And the biggest question is this: when a judge gives you one chance to prove you've changed, what happens when the court decides you failed?
The comment that I have for you, Mr. Anderson, is I understand you have a young daughter and you want to be there for her. You want to support her in any way you can. Just keep in mind that if you come back before me and you have violated one of my orders or you otherwise break the law, you will not be able to use her as an excuse. You are on notice. You know you have a daughter. You know you need to be there for her. So I'm not going to listen and say, well, Judge, you can't send me to jail or prison because I got this daughter. Well, you better think about that now, because moving forward, you can't simply throw that up in my face and say, well, I have a daughter. No, it doesn't work that way. You're on notice. I'm aware you have a daughter. I'm aware you're trying to get your families to stick together. But if you're going to resort to violence or you otherwise break the law, just keep in mind that will not be an excuse.
Judge, on behalf of the state, my understanding is that Mr. Anderson has 3 days jail time credit. We've received a recommendation from probation. I will defer to probation on this, but I do want to put on the record I have a lot of
This
concerns
first
about
phase is all about whether Anderson is suitable for community control rather than immediate incarceration. The state is already expressing concern about the underlying facts and specifically asks for strict supervision and treatment because of concerns for the alleged victim's safety. But then comes an important counterpoint. The woman involved tells the court she wants him on probation, says they have been living together, and says she does not have safety concerns for herself or their daughter. The defense adds employment, family responsibilities, counseling, and stability to that picture. So the judge has competing considerations: public safety and accountability on one side, rehabilitation and family stability on the other. Which factor would you prioritize?
Your Honor. All right. Mr. Brewer.
Judge, as you're aware, I filed a memorandum in support of sentencing, and we are asking for community control. Only to touch on a little bit, I think Ms. Anderson just touched on it, but Mr. Anderson does have a full-time job. He has maintained full-time employment throughout this entire process. He does provide the health insurance for their newborn. Through this process, when the protection order was released back in November or so, they lived together for this long, and it's not to say they never had any arguments, but none of them have been violent. They've gone through counseling. He's helped take Brandy to her doctor's appointments. He was there for the birth of the baby, so they've been together. They've been through a lot. There were a lot of stressors back in during the summer, and that came to a head. But I think they've sought counseling between them, and they're doing what they can to resolve those particular issues, and we're just asking that you consider him for community control.
Mr. Anderson, is there anything you'd like to say?
I'd just like to say I'm really sorry that any of this ever happened. I've never had a history of violence at all. Me and my wife, we just got married, found out that we weren't married, found out that she was pregnant, so we had to get married again to make it legal. We moved into a new house. We were just under a lot of stress. We got into an argument. I should have just walked out the door. We both did things I'm not happy about. I love my daughter. I've made a lot of changes in my life to get where I'm at today. If you talked to me 10 years ago, I'm so much better than what I used to be.
And now Anderson makes his personal pitch directly to the judge. He apologizes, points out that he has no history of violence according to his own statement, describes the stress surrounding marriage, pregnancy, and moving into a new home, and says he has changed significantly over the years. Most importantly, he promises the judge that if given another opportunity, he won't be back. That promise matters because community control is essentially a structured opportunity to remain out of prison while following strict court conditions. The judge is about to decide whether Anderson is amenable to that approach, and the answer, at least initially, is yes, but the conditions are anything but casual.
All right, the court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has reviewed the pre-sentence investigation together with the memorandum filed on behalf of the defendant by Mr. Brewer and the attachments thereto. Mr. Anderson, I am going to find today that you're amenable to community control, so I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. I'm ordering you to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
You're ordered to successfully complete mental health counseling. You will complete the Batter's Intervention Program, and you will complete the Thinking for a Change course. It looks like you have 3 days jail time credit. The court finds that you have the present and future ability to pay the cost of prosecution. So although I'm not going to fine you, I will assess the court costs against you.
This is the key legal turning point in the first hearing. Anderson is not simply being told, "Go home and behave." The judge places him on 3 years of community control under Warren County probation and imposes several specific conditions: no drugs, alcohol, or marijuana, mental health counseling, a Batter's Intervention Program, and a Thinking for a Change course. The court also assesses prosecution costs and warns that failure to pay can lead to community service of up to 40 hours per month until those costs are handled or an appropriate arrangement is made. In other words, freedom comes with conditions, and the judge has already made the consequence of violating those conditions unmistakably clear.
You want to support her in any way you can. Just keep in mind that if you come back before me and you have violated one of my orders or you otherwise break the law, you will not be able to use her as an excuse. You are on notice. You know you have a daughter. You know you need to be there for her. So I'm not going to listen and say, "Well, Judge, you can't send me to jail or prison because I got this daughter." Well, you better think about that now, because moving forward, you can't simply throw that up in my face and say, "Well, I have a daughter." No, doesn't work that way. You're on notice. I'm aware you have a daughter. I'm aware you're trying to get your families to stick together. But if you're going to resort to violence or you otherwise break the law, just keep in mind that will not be an excuse for you. Do you understand me?
Yes, Your Honor.
There is no contact order issued at the request of the victim in the case. Is that correct, Ms. Tranter?
Yes, Your Honor.
Ms. Tranter, is there anything else?
Nothing further.
Mr. Brewer?
No, sir. Thank you,
All
Your
right.
Honor.
Good luck to you.
The warning couldn't be clearer. Being a parent does not create immunity from the consequences of a future violation. The judge acknowledges Anderson's daughter and his desire to support his family, but makes accountability the priority. Then comes the crucial setup for what happens next. The court confirms that there is no no-contact order currently in place at the victim's request. At this stage, Anderson has community control, treatment requirements, and a very direct warning from the bench. But only moments later in the timeline, the case takes a dramatic turn. The court is back on the record because there is now an allegation that Anderson violated the very community control arrangement he was just given.
Mr. Anderson, there's been an allegation you have violated your terms and conditions of community control. Can I please have a reading from the probation department?
General condition number 1, on May 24th, 26, the defendant committed the offense of domestic violence F3 and was charged in Lebanon Municipal Court, reference case number CRA 2600270.
Sir, did you hear those allegations as they were read out loud?
Yes, I did, Your Honor. They are allegations.
And at this point, the court finds that there's probable cause that you have violated your terms and conditions of community control, so we'll set this over in front of Judge Teep. Do you have the means or ability to retain counsel, or do you need a court-appointed attorney?
I have a lawyer. Yes, I do.
Who is your attorney?
David Brewer.
Okay. Was he appointed or retained?
I paid for him.
Okay, and you retained him for this PV as well? Perfect.
All of it.
We will get this set with Mr. Brewer while this is
Now the
pending.
stakes jump dramatically. The probation department alleges that on May 24th, 2026, Anderson committed a third-degree felony domestic violence offense while under community control. Notice the wording, though. At this point, these are allegations, not yet a final finding of guilt. The judge finds probable cause for a community control violation and moves the matter toward a hearing. Anderson has retained counsel, and the state asks that he remain held. That distinction between an allegation, probable cause, and an eventual guilty plea is critical. The court still has to follow procedure, but the timeline is already becoming a major problem for Anderson. He is accused of committing a new offense while serving the very supervision that was designed to keep him compliant.
We would ask that he be held at this time pending a hearing in front of Judge Teep. I'm not sure what his bond is in the lower court. He has a $100,000 bond with EMHA in the lower court. This is a relative, he has not been on probation that long. We would ask that he be held.
Mr. Anderson, anything you would like me to know with regards to bail only, keeping in mind you have the case pending, so you don't want to go into the
Yes.
facts or anything?
So I have been in excellent stance with all probation throughout pretrial, when I was on house arrest, all the things, made it to every appointment, passed every drug test. All I'm asking is that with these allegations, I'm going to take this to trial. If I could get out on bail, go back on house arrest, I have a house I can go to that's nowhere near this alleged victim. I'm in the process of getting a divorce also. I filed. I think she's just upset, a couple of other things, but I'm willing to post bail and abide by everything needed.
I'm trying to look right now. I'm not aware of whether he's posted bond in that lower court yet.
Well, I was told I had a folder, so I didn't put any money down because I didn't want to lose the catch.
If the court is inclined to release him, we don't believe an OR in this case. I mean, for the protection of the public and his ability to reappear, he certainly has consequences he is facing, potentially.
Like I said, I'm willing to go back on the monitor or whatever. I'm just trying to get back to work and then have my right to go to trial.
Where are you working right now?
Valco Melton, I've been there for almost 5 years. It's a machine shop. Was under Officer Edwards the whole time I was on ankle monitor. Got moved to Conroy, and then got moved to Robert Henry. And every one of them I've passed everything, done everything I needed to do.
There is also a domestic violence CPA.
And this is where the procedural story becomes even more important. Anderson argues that he previously complied with probation, made appointments, passed drug tests, and had a stable job. His attorney asks for release under house arrest and points out that he has a residence away from the alleged victim. But the court is dealing with a new high-level felony allegation and a pending domestic violence protection matter. The judge therefore keeps him in jail while the violation is set for a final hearing, specifically noting that the court must account for the presumption of innocence on the new charge. Then comes the next major development. Anderson ultimately changes his plea to guilty on the new domestic violence case and admits the community control violation.
Numbers 25CR42912, 26CR43684, the State of Ohio versus Kenneth Anderson. Okay, Mr. Anderson, with regard to the 26 case number 43684, they're telling me that you're going to change your plea to guilty. Before we get to that, I'm required to go over some things with you. Okay, sir? How old are you?
35.
How far did you go in school?
I graduated high school with a 3.8 GPA, and then I went to trade school, finished that with a 4.2.
Are you able to read and write?
Yes, sir.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you other than this recommendation that the attorneys are making to me?
No, Your
This
Honor.
document says you're entering a plea of guilty to one count of domestic violence. As a felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. Do you understand the maximum penalty?
Yes, Your Honor.
Ms. Tranter?
Your Honor, this occurred May 24th, 2026, Warren County, State of Ohio. On that date, Kenneth Anderson did knowingly cause or attempt to cause physical harm to a family or household member having previously been convicted of domestic violence.
Mr. Brewer, anything on those facts?
No, sir, Your Honor.
Mr. Anderson, did you hear the statement that she read?
I did.
Do you admit that what she stated is true?
Yes,
And again, you understand all the rights you're giving up when you enter plea of guilty.
I did.
What is your plea?
Yes.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Under case number 25CR42912, the probation violation, Mr. Brewer, does your client wish to have a hearing on that?
No, sir, he will admit to the violation.
All right, Mr. Anderson, on that charge, on that case, you understand you're entitled to have a hearing,
I do.
and you wish to waive that hearing and admit to the violation.
Yes.
And the final outcome is severe. Anderson ultimately pleads guilty to the 4th-degree felony domestic violence charge, with the court noting a maximum penalty of 18 months in prison and a maximum fine of $5,000. He also admits the community control violation and waives his right to a violation hearing. The judge then finds that Anderson is no longer amenable to community control and orders 6 months in prison on the violation case, with 84 days of jail credit. On the new case, the court imposes 12 months in prison to run consecutively to the 6-month sentence, making 18 months total, with the 84 days of credit assigned to the first case. The judge specifically cites punishment, deterrence, protection of the public, and Anderson's failure to respond to previous community control sanctions. What makes this case especially complicated is what happens afterward. The victim speaks about the family's severe stress surrounding their hospitalized infant, acknowledges her own struggles, and says she is not completely certain that every fact in the original report was accurate. But the judge explains that the court must rely on what is actually established in the proceeding, and Anderson himself admitted the factual statement when entering his guilty plea and admitted the community control violation. The judge ultimately makes clear that this is now a prison sentence, not local jail time, and that the Department of Corrections will determine his placement and available programming. So what do you think? Did the judge give Anderson a meaningful opportunity for rehabilitation before the violation, or was the 18-month consecutive sentence too harsh? And does the victim's latest statement change how you view the case? If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.